So many times I get asked this question when I meet with a new client that's been involved in a car accident here in the Tampa Bay area and in Florida in general. And the question is, Greg, what can we do if indeed the at-fault party who was driving the car that injured me didn't have bodily injury liability coverage? Maybe that coverage lapsed, or they didn't have bodily injury liability coverage. And my question is that we're probably not going to know the specific answer to that question when we initially meet on the case. But we're going to do our investigation and determine for a fact whether indeed the at-fault party had bodily injury liability coverage. And we're going to make sure that if that person was driving a vehicle that was owned by someone else, whether or not the owner of that vehicle had bodily injury liability coverage. And here's where it's very important, and this is where clients say that they didn't know this. In Florida, a person does not have, that owns a motor vehicle or drives a motor vehicle, isn't specifically required under Florida law to have bodily injury liability coverage. It's not a required type of coverage to drive a car. The only type of coverage that's required is property damage liability, which won't cover your personal injuries, and what we call personal injury protection or no-fault coverage. Those are the only two required types of coverage that a person needs to drive a car. And so we're going to be telling you from the very beginning, look, if indeed it's determined that that at-fault person who was driving the car that caused your injuries, that caused the accident, if that person didn't have liability coverage, bodily injury liability coverage, or the owner of the vehicle, if it's someone different, didn't have bodily injury liability coverage under that car, then we're going to be moving to step 2 of our investigation, which is determine if you have uninsured motorist coverage under your policy, or if you're residing with a resident relative that owns a motor vehicle that has uninsured motorist coverage that we can look to try to recover for your injuries, damages, and losses. If the at-fault party didn't have liability coverage that caused this car accident, or had such an insufficient amount of bodily injury liability coverage that it wouldn't fully cover your injuries and the value of your claim. So we're going to be looking to that step if that person didn't have either any liability coverage or not sufficient liability coverage, then we're going to be looking to determine if you have uninsured motorist coverage that would protect you. And one thing I want you to keep in mind, which is very important, because sometimes you might be saying, or I've heard clients say, well, Greg, I really don't want to pursue my own insurance company because my insurance rates will go up, and I don't want to see that happen. And while I fully understand that, I would tell you this. Under Florida law, an insurance company cannot legally raise your insurance premiums for you pursuing an uninsured motorist claim for an accident that was not your fault. They cannot do that solely on the basis of you pursuing an uninsured motorist claim.